agree to do it, or you can refuse to do it. It's just totally up to you. Were you advised of this?
No.
All right. These are the prosecutors, and they just want to explore what you have to offer in this case. Are you willing to be interviewed by them?
No.
All right. Step up.
Your Honor, could witness be advised that a failure to...
Oh, yeah. I just want you to know, and Relly will be told the same thing. By refusing, this can be brought out on cross-examination, that you refused to be interviewed by the prosecution, which could impact your credibility. But that's totally your decision. If you don't want to talk to the prosecutors, you don't have to. If you agree to, you can. But I just want you to know of the consequences.
I understand that.
You still don't want to speak with them?
Correct.
All right.
I'm assuming he'd be given an answer as to why he doesn't want to.
Correct.
Yeah, if he's asked?
Yeah.
Yes,
Okay.
of course. If he's asked, if he's confronted with, isn't it true that we wanted to speak to you and you refused, he'll say yes. And then the prosecution asks, or you can ask, why did you refuse? Sure. If it's touched on direct, it can be touched on, if it's touched on cross-examination, you can touch on it on redirect. All right, step out, please.
Thank you.
What about Phillips?
Your Honor, before you go on to Mr. Phillips, we still do not have, counsel has never provided the date of the interview with him. How many there were?
Would you wait? I have things in a certain order. What about Phillips? Where is Phillips?
He's in
He's in New York?
He's in New York. But we contacted him and alerted him to the fact.
Okay, call. Can you call him?
Sure.
Did you get birth date on Mr.
Does the state plan to rest today? Because those sound like defense witnesses. Maybe they had to appear to, because the prosecution wanted an answer on whether they would be interviewed or not. But if they're supposed to take the stand today and they're defense witnesses...
What is Phillips' first name?
Jamel.
Jamel.
Jamel?
Jamel.
I'm not trying to be judgy, but I think this might be witnesses to the incident that the police failed to identify, or the prosecution chose not to investigate further for information.
All right. Mr. Jamel Phillips?
Hello, how you doing?
All right, Captain. All right, Mr. Phillips, I'm the judge in the case. You're aware of the case, yes?
Yes, sir.
All right. Two things I want to inquire of you. At some point, you're going to be coming to court to testify. You're aware of that?
Yes, sir.
All right. The prosecution would like the opportunity to interview you before you take the stand, just to find out what you have to offer and what you have to say. It's optional with you. You can either you can agree to be interviewed, or you can refuse. Are you aware of this? Are you aware of this?
Yes, sir.
All right. Will you agree to be interviewed or not?
No, I do not want to be interviewed.
All right. I want you to know, though, if you refuse, then the jury is going to know that you refuse to be interviewed by the prosecution, and it could impact your believability, your credibility in the eyes of the jury. Do you understand that?
Yes.
All right. What I'm going to do now is I'm going to have you take an off speakerphone, and the phone is going to be given to the bailiff. Mr. Phillips, I want you to give your birth date to the bailiff. No one is going to be able to hear it except her. She's going to write down your birth date, and she's going to give it to the prosecution, because the prosecution is entitled to at least look into your background, and part of that is required that you give your birth date. But it is not going to be broadcasted or publicized in any way.
Your Honor, the court also inquires whether or not he has a residence outside of New York, or has had a residence outside of New York.
Do you live here in California?
No.
Do you have a residence here in California?
No, not under my name. No.
Not what?
No.
So
Do you
he's
have a residence
voluntarily.
anywhere beside New York?
No.
All right, so when you were out here, were you just visiting?
Yes.
Okay. All right, go ahead and take it off speakerphone. All right, and Deputy Bennett, let him know when he's off speakerphone, and then have him give you the birthday.
And this goes to having a capable attorney with time, with
Do you
money
want
for
him
private
on,
investigators.
24-hour call, or is that handled?
These sound like witnesses that the defense went and found on their own,
All right, you have the birthday?
who are voluntarily agreeing to
All right,
testify.
getting back to Mr. Levin, since he's being called as a witness, how many times has he been interviewed by anybody from your office?
Twice, Your Honor.
Okay, when was the first one?
That would have been mid-August, Your Honor.
About 24?
21.
And where did the interview take place?
In our office in Tacopina.
Was the interview recorded in any way?
It was not.
Who was present for the interview?
Mr. Tacopina and Ms. Manzoni, along with myself.
How long did the interview last?
I'm trying to recall, Your Honor. About an hour and a half.
Hour and a half. And nobody took notes or prepared a written statement as to what Mr. Levin said?
No, Your Honor, it was a conversation.
I had said that the people are entitled to at least know the sum and substance. Since there's no written recording of what happened, the people are entitled to know the sum and substance of your conversation. So that is to be generated today.
We did that, Your Honor. We provided it.
Oh, you did?
Yeah, the court, if the court recalls, Your Honor, the court made.
Look at the prosecutor. He said,
Did they?
What we originally got was, we got a paragraph saying he was going to talk about his observations, not what the observations were. The day before we started trial on the 20th, we got approximately a 15-line summary that certainly would not take an hour and a half. No dates as to when the interview occurred. Nothing about who was there. By the way, even now, what they're just told the court is, there's an interview in mid-August that can't even say what date it was. And what they gave us was simply, apparently, a combination
What's
of
the date?
everything he said.
I know you know what date it is, so what's the date?
It would have been August 16th or 17th.
All right. When was the second time you interviewed him? About? No, not about. When was the second time?
Your Honor, of course, I'd like to have questions to go with too, right? On this. I mean, we have the same issues with some of the other witnesses, right?
All right. Well, let's deal with this, and then I'll listen to what you have to say. All right, when was the second time?
It was the 26th, Your Honor.
So 10 days later?
No.
No, 2 days ago, January 26th.
Oh. Where did that interview take place?
That was at our hotel.
How long did that interview take?
Yeah, about the same amount of time, Your Honor, an hour and a half.
So, was that interview recorded in any way?
oops, sorry. I am pulling up. I'm sure we'll see it again today because the witness didn't finish testifying. But I am going to pull up the body-worn camera video that I'm thinking is connected to at least one of the witnesses that the state seems shocked by, that the defense plans to call. Oh, is it? See, I thought it was me again that froze the thing. It wasn't me. The ticker's still moving. The law and crime ticker's still moving. So law and crime camera. Oh my God. Oh my God. They're quick with putting the feedback up.
3 hours worth of interviews. We had a total of about 15 lines. The court's aware, on the 20th, the court expressed skepticism, excuse me, on the 15th, the court expressed skepticism that the defense did not record it, did not write anything down, did not have any substance as to what was said.
Right.
So apparently, after the court gave that lecture, they conduct another interview 2 days ago, where again, they don't record it, they don't make any notes about it, and they don't turn anything over.
They're not required to.
It's not their
If they
burden.
choose to do their job that way, then they do their job that way.
You know, they are required to let us know.
And they
that
did.
they have interviewed the defendant, or the witness.
Yeah.
They have to let us know that interview took place, when it took place, who was there. It appears, again, I'm not gonna-
You got 15 pages.
It's very
or
clear
lines.
what's going on.
All right, so what do you suggest?
Well, what I suggest is I find it completely disingenuous that we have 3 hours now worth of interviews. We got a total of about 15 lines. Very little detail about what's going on. And so if all of a sudden he ends
Too
up
bad.
testifying to more detail than he gave, and the court already has because we've sent it, if he ends up testifying to more detail than what he has previously provided in this miniaturized summary, then we've got a discovery violation.
Are you, who's going to be, a question? Is that you? All right, are you going to be going into any subjects or areas that are not covered in what you gave to the prosecution?
No, Your Honor.
So there is nothing that you are going to ask about that does not fall within the summary.
That's correct.
Correct. Okay, then I think there's been I think discovery's been satisfied.
Well, at least this point,
Right.
we can't demonstrate the discovery is not been satisfied because he hasn't testified yet. Does the court really believe that we have 3 hours of interviews and 15 lines? I don't.
I have, this is not the first time I've been aware that lawyers don't take notes of interviews. If Mr. Siegel represents to me that no notes were taken, or Mr. Tacopina represents to me that no notes were taken, I have no basis to disbelieve it. Would I do it that way? No. But if they choose to do it that way, that's their choice. He told you, Mr. Siegel just told you, that any topic that's going to be inquired about is in the summary that you've got. So for now, discovery has been complied with. All right, let's talk about Phillips. When was the first time Phillips was interviewed?
That's what
Oh, is that one
We were just talking about Levin.
no.
No, we're talking about Phillips.
Levin. We were just talking about Levin,
Oh,
right? We're not talking about Phillips. All right. When was the first time Mr. Phillips was interviewed?
It was a week after we interviewed Ms. Letter.
All right, around August 23rd?
That's right.
And where did that happen?
In the office.
Okay, and who was present for that?
Same circumstances, Mr. Tacopina, Ms. Lanzoni, and myself.
And how long did that interview take?
Now, I want to hit a pause here. So the defense does these interviews. So this incident happened in November of 2021, right? Then we hear that they searched A$AP Rocky's residence in April of 2022. Now we're hearing we've got these interviews taking place in 2024, August of 2024. So the defense is interviewing 2 different individuals who are both willing to testify voluntarily. It doesn't sound like they need to issue a subpoena. The one guy's out of state, right? So, but he's saying he's calling up the court and seems voluntary. If you ask me, they want to come testify and the defense is calling them. 2024, they both get interviewed in August. Doesn't that seem like the defense happened upon something that helped them find these 2 individuals around the same period of time? So this all happens November 2021, and something in August of 2024 lets the defense team identify 2 persons of interest that they might want to interview. And then the state is mad, like, oh, we don't get to know every line about what they discussed. You don't get that right. You don't have that right. There's different burdens and standards. You know, Brady violations are prosecutorial violations, right? There is no Brady against a defense attorney. There is no Brady violation against a defense attorney. right? There are still some discovery obligations, right? Like you got to identify your list of witnesses. If you plan to call an expert witness who's going to deliver expert testimony on a subject, you've got to provide a CV letter and the scope of what you plan to have them discuss. That's why the judge was so like, all right, you turned it over? You gave him a thing? All right, you're good. But isn't it interesting that you have a 2021 incident and the defense is interviewing these people in August of 2024? If the state is mad about the timeline, oh, August 2024, what was it that you turned over in discovery in fall of 2024, late summer of 2024, where the defense attorney on their own went and connected dots that you weren't willing to connect? And then the prosecution sitting here whining about it to a judge who clearly doesn't want to hear it. So, you know, I think it's hilarious. Again, the jury's not in the room for any of this, but we've heard some of this type of objecting and opening statements. The prosecution objected multiple times. This same type of persistent, seems to me like whining, just because this is outside the presence of the jury, I think it's already being, it's like a tangible presence of the prosecution being upset. We left on this cliffhanger of this exhibit, and it paused my stream when I tried to pull it up. I'll show you the screenshot, I'm sure, with Rizzo back on the stand. We're going to look at it again. But what I was referring to, let's get the last clip. Day 1. And it was at the very end of day 1. So if you didn't tune all the way into the end of the day, that's why you're not aware. But the detective on the stand, Rizzo, he was surprised because I think this is Rizzo standing over here. Prosecution was like, objection, Your Honor. And one of those, like, it seems like you're ruining my case type of objections. When the defense moved to introduce this body-worn camera footage. And someone was moving in this footage here. My guess is it's a homeless person who, this is the scene of the crime where things took place. Prosecution panicked yesterday when this video came up. Judge was like, what do you mean? Foundation's been laid. It's coming in. And now we're panicking about witnesses and how they were interviewed. I'm wondering if this is one of the guys that the defense is calling. Likewise, maybe one of the other witnesses was somebody that was in the area that the DA, prosecutors, failed to reach out to, failed to interview, and now they're mad because the defense went and did the investigative work, and these individuals are willing to testify for the defense without speaking and giving an interview with the prosecution first. If someone doesn't want to speak to you, do you think what they have to say would be helpful to your case? So I think this is my guess on where we are and why we're having this panicky discovery issues motion hearing this morning. Again, we'll see how it plays out as the day moves on. But oh boy, isn't it crazy to see the prosecution scrambling about discovery issues?
Yeah, cut it out, Your Honor. 1 hour.
Yeah, Darcy, the state only called that first cop on Wednesday when ASAP rejected that plea.
Did you provide a detailed outline of the sum and substance?
We did. At the same time, we provided that detailed sentence.
Now, do you intend to go into any areas with Mr. Phillips that are not within the summary that you provided to the prosecution?
No, Your Honor.
Okay, how many other times did you interview?
That was here.
That's the only time?
That's right.
Just so it's clear, Your Honor, we provided literally with about 12 lines of Mr. Levin's alleged testimony. The issue is not...
We're talking about Phillips now.
Excuse me. Levin was 12 lines. Phillips was 18 lines.
Okay.
And I should just add that the issue is not that they're not going to cover a new area. It's that, as an example, when Mr. Phillips is talking about the actual incident, there's very little information there. It would appear, as the court is aware, the first thing that they said in discovery was that the witness would testify, quote, about his observations during the incident. So they then follow it up with, well, okay, we're now going to tell you apparently a little bit about what he's going to say. So again, Your Honor, this is our concern. Because we've provided with so little of what actually happened, it's not that we're going to introduce a new topic. It's that all of a sudden, these witnesses are going to get on the stand, and the amount of detail they are going to give is going to be completely inconsistent with the minimal information that we were given. When you add in the fact And again, they're not required to take notes, but they are absolutely required to immediately after provide, if they're not going to take notes or record, an accurate summary and statements of what the witness has said. So our concern is, we basically were given nothing, almost zero. They're going to get up on the stand after, again, 2 hours for one, an hour for one, 3 hours prior to the other, and they're going to testify in greater detail. That, when you combine that with the prior attempts and not turning over discovery, even after the court's order, leads to the inescapable conclusion that they're not complying with the meaning of the letter in the court's order. So I understand the court doesn't have anything it can do now, but the court has been furnished with the discovery they provided. It's not a long read, as I said.
I haven't been provided anything.
It's in, I believe it's in the emails that we have sent. So if not, I will give the court a copy, but it's literally on one page for both of them.
If I'm understanding you, Mr. Siegel, that any topic that you're going to cover on direct examination,
I'll be
Mr.
doing
Levin,
this, Mr. Phillips.
all right. Am I correct in assuming that any question that is asked on direct examination by either counsel or Mr. Levin and Mr. Phillips is encompassed in the summary that's been given to the prosecution?
Yes, Your Honor.
All right, I just wanted to yes or no. All right.
And I'd like to say more than one word.
Wait. All right. I don't see any other topics to go into. All right.
In terms of, on this issue, so
For now, this.
there's a couple of other issues that people have. The first issue relates to, it's not just the real evidence of profit. We've been focused with only 2 witnesses at the call.
Right.
It is our understanding there will be no other witnesses that will be called to testify about profit. As the court's aware, counsel and I have been asking for days, in email the court is talking to you, are you planning on producing the gun in this
He
case?
said no.
Well, they refused to answer that question the last week we've been asking. They've also answered the second question, are they now planning, which would be against the court's discovery order, to call any other witness regarding the profit information? And the court please inquire, we've only been told there's 2 witnesses they're calling, plus maybe the defendant.
So, any other witnesses that you intend to call or reasonably intend to call?
But the only possibility is sitting right to my right, Your Honor, right?
All right, so it's either the Levin, Phillips, and Rossi, or just Levin and Phillips.
Yeah.
The next issue that we would have, Your Honor, is we want to make sure, there have been times where counsel has asked to approach, but he still wanted to be on the record. Our position going forward is that unless it is something having to do with an issue with the jury, the prior times occurred before the jury was selected. Counsel made certain arguments in open court, then he asked to approach, and he made different arguments, but he wanted to do it on the record. Unless the court orders it, and there's a good reason, the last time this happened, Your Honor, as the court is aware, counsel elected at his request to give a speech that he was very happy with this jury, wanted it to be known that he was happy with the jury.
Give a speech to
Your Honor,
who?
Your Honor.
Stop, don't interrupt.
Okay, fine.
You'll have a chance.
Oh, I know, but he should.
You'll have a chance.
I know
Wait
he's
till he
doing right.
finishes, then you will have a
I
chance.
know what he's
Is
doing.
he ever gonna
Do
finish
not
though?
interrupt neither of you interrupt the other.
Don't interrupt his
David,
whining.
He said, I need to say something in open court. And then he made a statement about how they were very happy with the jury. Clearly, it didn't matter to the court. He then asked to approach. When we asked to approach, he said he wanted to do it on the record. On the record. But outside the press, he then complains about jury selection, about a specific juror, etc. We are not going to participate in Mr. Tacopina's attempts to manipulate the media. Again, that ties into the fact that when the case started,
Not a penalty
I very
box.
kindly said to Mr. Tacopina, hey, listen, I know you've been speaking to the media before trial. There was no order, you have every right. Are you going to be saying anything once the trial started? He assured me in front of my co-counsel, the response was, John, I would never do that. I won't be saying anything to the press. Meantime, he is speaking, I already sent the court this, he's speaking to TMZ. He likes to say things to the press as he leaves the building. We took him at his word that he wasn't going to be talking to the press while the pendency of this trial was going on. This is necessity. As an example, we ended up hearing his arguments basically about the jury issues repeated by Al Sharpton. We're not going to try this case in the press.
Why do you say Al Sharpton like that?
To order Mr. Tacopina to not speak to the press during the pendency of this trial.
Okay.
All right. First of all, I hate that because prosecutors always whine when defense attorneys speak to the press. We are dealing with a situation where, you know, A$AP Rocky and his family are especially heightened in the public limelight, right? So there's even a bigger reason that an attorney might want to speak the defense out into the open, out into the press. It's not illegal. It's not unethical to speak to the public, to speak to the press as a defense attorney, right? It's not illegal. There's certain things that could be crossing the line. You shouldn't be talking about things that are under seal, things that, you know, are private information, things that haven't been disclosed to the court, you know. I don't know. Has Joe Tacopina said anything that would violate somebody's confidentiality? Prosecution didn't allege that. He's whining that he spoke to the press. There's no bar that prevents an attorney from speaking to the press unless there's a gag order in place. And that gag order shouldn't be broad stroking anyway. It should be, you know, should delineate this, and this, or that are off limits. Prosecution is seriously just whining. So, like, oh my God. Also, big shout out here. Chloe Albert's Revenge has me dying in the chat. As always. First of all, let this be the time, guys, that we learn, especially thinking of TMZ, speaking to the press. TMZ ran a post that, you know, Rihanna might be showing up in court. And I think for what it's worth, I get that that's a big spectacle, whatever. But at the same time, the jurors, especially since Rihanna was in a PowerPoint slide put up by the prosecution, the jurors might be wondering, Rihanna's not here? We want to see Rihanna for X and Y, Z number of reasons. But why isn't she here supporting A$AP Rocky? Does she think he's guilty? So there's, you know, it's important to have your friends, family members, people that are close to you show up for you. Have someone sitting behind you at trial. Nobody wants to see one party have 30 people behind them and the benches behind the other party are completely empty. Maybe you shouldn't make inferences about that, but again, jurors are human. So TMZ ran this story like, hey, we think Rihanna's going to show up. You know, the reason for that being there had to be notice to the judge, to the court, because the court needs to prepare for the extra security burden of having a high profile, very high profile celebrity in the courtroom, right? So that's probably actually happening. This is a great time, and Chloe Albert's Revenge is giving us the reminder. A$AP Cat Chat, the collective, it's Rihanna. Rihanna. Let's get her name right. It is not RHI. It is not RIANNA. It is R-I-H, Anna. Or Riri, if you want to keep it simple. Miss Fenty, if you're nasty. So I love this here. We're getting into this TMZ conversation. I do think we'll see Rihanna. I don't know if the cameras will pan on her, but I'm sure that will be some big event down at the LA courthouse. That'll be a time. Now, what's Joe Tacopina's response to this broad, vague criticism that he shouldn't be talking to the press?
I guess I'll start in reverse. First of all, I'd like him to provide a quote of what I said to the press, because one thing I've never done is speak about the facts of this case since the jury's been out. Never. Okay? But I do have here a quote from the district attorney, Mr. Hoffman, who did quote to Extra that he appreciates any time defense counsel is pretty sure they're going to prevail, but we don't bring cases unless we're very sure we can win those cases by establishing and meeting our burden of proof beyond a reasonable doubt. I believe that when we see the evidence that's going to be presented in this case, we'll meet that burden. So that's their district attorney. Okay? So I should be able to rebut something like that. That's different. That's saying we're going to win the case, we know the evidence, and we'll meet our burden.
And I love this. This is not the only time that this has happened. It's happened in the Courtney Clenny trial to an extent where at first, and from what I've looked at, I think Courtney Clenny has a huge uphill battle. I don't think she can make her argument that it was battered wife when she murdered her boyfriend, killed her boyfriend. But the state came out, the prosecutors came out and took issue with the defense attorney speaking to the press. And again, another high-profile defendant, right? She's a multi-million-dollar earning OnlyFans model, an Instagram influencer. State took these issues with the defense attorneys speaking to the press, and they gave a very specific argument for one of the things when the judge said, you can't just not let them speak to the press. So what's your actual issue? Like, if I'm going to consider a gag order, it's got to be very specific. So then they said, like, out of nowhere, completely unfounded, the defense attorneys mentioned potential abuse in the past of the victim's upbringing. And it was unfounded. There's no basis for it. Well, it turns out in their own discovery, things that they pulled through iCloud warrants that they obtained in their investigation into Courtney Clenny and her parents, there's messages that Courtney Clenny wrote in her own notes that talk about what Christian Obumseli, disclosed to her. And now the prosecution looks stupid because not only are they getting up in arms and wanting a whole gag order, they only tried to limit it when the judge said, you're crazy. I can't just give you a gag order against an attorney. What's the specific issue? Then the specific issue they gave, they made themselves look dumb because there actually was a basis for it, right? So we're having the same thing kind of play out here. We are only responding after the defense attorney made public statements. So you get these prosecutors, these district attorney's office, state attorney's office, they get these high profile cases and it's like they can't help but make a statement. And then they get mad when whoever's representing the defendant says something back. And it's just absolute whining. It's absolute whining. Because the restrictions, if anything, favor the defense, the right to a public defense. They don't favor the state. Yeah, exactly this honeypot. True for thee, but not for me. And then they look stupid arguing it in court. Also, huge thank you here. Chad Diggy is out here sniping away. So I see FFS showing some love. Guys, show Chad Diggy some love. Chad Diggy, great person. So much fun to have in the chat. Thank you for the support. But Chad Diggy was just like a bubble of information when it came to covering the YSL trial. She knew so much, like trivial stuff, but also important stuff, interesting stuff. She also she drove around and went through that intersection where there's like the overpass and the one-way, the left turning lane, to give us a better idea of what the Chamel drinks, that whole intersection looked like, how that whole scene would have played out, and, could someone have been in a left lane to make a turn or not? So very, very important person to this community and so many others. So glad you're here, and big appreciation because you're gifting 1, 2, 3, 4, 5. You're just sniping people down in here. So show Chad Diggy some love in the chat, you guys. Let's get back into this before I keep talking.
I talked about nothing other than potential issues with the jury. I didn't speak about the facts, I didn't speak about Mr. Efron. And I won't do that. Now, the last thing he said was I spoke to TMZ. Again, I defy him to provide to the court what I spoke about, because I didn't violate any order. First of all, there's no order. But I know enough not to speak about the facts of the case. By the way, I didn't opening statement to the jury. Certainly, I would never say anything outside of that opening statement, but I didn't even do that, Your Honor. I simply talked about the issue with the jury. And the reason I did that is because he just did again what he did the other day. Stood up and said, we're not happy with this jury. Try and get that message back to the jury that we're not happy with them. That is not the case. But, Your Honor, the reason I raised the issue about maybe we would have selected a different jury, or certainly a different juror or two, is because of the late disclosure of the ballistics report after a jury was impaneled. And we have a right to make that record. It doesn't mean I'm unhappy with the jury. So, speaking of disingenuous, we're going to now get into disingenuous. But I did nothing but protect the record, protect my client. So that's first and foremost. So again, the issue that I spoke about off record was caused by their late disclosure of a report that was generated over a year ago by their lead detective in this case. that Mr. Lewin wants everyone to believe he just stumbled upon 3 days ago.
Well,
He just stumbled upon 3 days ago.
you don't have to whisper, just talk.
Try to get that middle ground there.
Just talk in the normal tone of voice.
Yell so we
That
can
he
hear
just
you out
stumbled upon
here.
3 days ago. You know, he made all these accusations about that's disingenuous, I don't believe it. Well, I don't believe that they just found that report from their lead detective who they interacted on a daily basis in this case, 3 days ago. I don't believe it. That was done in January 2020.
I already made findings.
I understand.
In my view, nothing nefarious. I don't want to go over things that we've already gone
Well,
over.
we just did. We still have it.
He's asking that that both sides be directed not to make comments to the press. That's what he's asking for now. I'm not poking fingers. I'm not accusing anybody of any unethical conduct. Let's just move forward. Here's what I want to
I
happen.
have more things.
Oh, go ahead.
All right, I just listened to it.
Go.
Okay. Now, we heard a little about the discovery issues about, this not being enough. I mean, I think this is incredibly detailed when it comes to Mr. Phillips, especially with the videotape. This is really detailed. Tell us what he's going to observe at the scene, what he's going to testify to, what he observed at the scene. Putting that aside,
Based on what I've heard, I am satisfied, under the circumstances, that both sides have satisfied this discovery rules.
so let's
So
now-
there's no reason to go over about whether you have complied with discovery. I already found that you did.
Okay, now I want to talk about Ben. There was a police officer, the first one out of the box, Sergeant Zizzo.
Right.
The only thing we have from them, because, I assume the rules apply to both sides, right? The only thing we have from them is a few-line email saying we spoke to him on Wednesday. He testified Friday, recall. We spoke to him on Wednesday, and Jack, you have the email? I have it.
Yeah, in short, Tacopina, a big part of voir dire was, do these jurors, what's their trust level in police? Do they trust the police? Do they have a distrust of police?
That they spoke to him on Wednesday, which they also denied on the witness stand, by the way. He said the first time he spoke to him on substance was the day of his testimony. He said that he advised the district attorney that he responded to the shooting while on patrol, and it's common occurrence that they'll receive a call to shooting and respond only either to find no evidence or the victim, but also sometimes find out whoever called was intentionally misrepresenting. 2 sentences. That's the discovery. He testified that 1, he may have missed the bullet casings, and 2,
This is why they want to
he
bring the
didn't
other
know where to
witness.
look. 2 sort of important things that, and he didn't agree, he didn't search the entire street. That was not in their disclosure. Not in their disclosure at all. But yet I'm being accused of not giving them the right information. First of all, I don't have the date. There's nothing in their disclosure that they interviewed him private before his testimony. We don't even have that interview. We don't have that date. We have Wednesday only. The witness said, no, I didn't speak to him on Wednesday or something. That was just about logistics. Okay, so before we start casting aspersions, I wasn't going to even raise it, Mark. It just happened. I understand this is trial. But, being that we're now throwing stones, let's call the kettle black.
Let's not throw stones.
Well, I know, but they started. So I'm going to respond.
This is a no squabbling zone.
Oh, after he
No
swallows.
squabble?
Well, I'm swallowing back.
Where's Steph JK?
Well, you're a good
Kiss and
squabbler. You're doing a good job squabbling. All right.
Ugh.
Regarding what Sergeant Zizzo testified, did he write a report?
He did not write the report, Your Honor. But he obviously bore body worn video.
That's been provided.
That was provided.
All right.
Years ago.
You're an experienced attorney. All of you are experienced attorneys. Sometimes, a witness will say something that is not in a report. That's to be expected. A report is a summary, a sum and substance of what the witness said. it's much more fleshed out when the witness is on the stand.
Well, I agree with that. I'm okay with that. I'm not even gonna I'm not even gonna raise the fact that he said he didn't speak to him on Wednesday and he almost woke up. I don't do that. It's petty.
It is petty.
But I want to make sure that what's good for the goose is good for the gander. That when Mr. Phillips testifies and he says something, a word that's not in this thing, it's not like, you didn't tell that to the lawyers. It's just not right. No one, this is not a transcribed statement. There will be nothing outside the scope of this. But in the same way, I didn't get anything from them regarding, I may have missed the shell cases. I didn't get a report that said that or a statement.
Again, to be repetitious, I do not find either side has violated any discovery statute or any discovery rule. Regarding the press, the jury has been told not to read or watch anything about this case. I'm going to assume that they follow that rule. But what I am concerned about is someone that the jury knows is going to read or watch something about the case and then relate it to the jury. So, here's the rule. I don't want any attorney in this case saying anything to the press while the case is going on. That's it. So you
They've got a gag order.
We will advise, obviously, courts where we've said nothing. We will advise the DA as well. To be clear, the DA responded to Mr. Tacopina's published report where he dared, quote, Nathan Hockman can try the case himself. And we're going to tell the DA.
Let's move forward. Yeah, just let everybody know
Nobody.
in your office who may say something. Tell them not to say anything to the media or the press.
Will do, Your Honor. We had two last issues which are brief. The first issue is we're going to request, and made this request before. Counsel and I've tried many cases in front of the court. If there's anything even close, I forward to in advance. If there's any evidentiary issue, which is even a close call, in terms of the defense introducing, bringing up, asking questions, we want to make sure that they have to approach and that we 402. We don't want to be in a position to have to unring the bell.
That goes for both sides.
Finally, Your Honor, court is
Both sides.
On Friday, it doesn't really matter what circumstance were. Mr. Tacopina
Look at ASAP.
started screaming at me in the
Screaming at me.
I'm not interrupted, Mr. Tacopina.
Yo, okay. All of our workers and lurkers in the bushes who are not looking at your screen, come look at the screen. Oh my goodness. Joe! Can somebody clip this?
I'm not interrupted, Mr. Tacopina. As I see, Mr. Tacopina.
Joe Tacopina! Oh my god.
Again, there's got to be a certain decorum. We're following it.
He put his hand on his shoulder. He said, bro, calm down.
So we would appreciate, as a court is respectfully instructed, and we're one lawyer's talking.
Oh, Trakisha, you got here just in time. Oh my goodness. Sorry, I'm talking over this whining argument. Let's go hear the whining. We'll look at the emote, the live action emote one more time. My bad for talking over or like squealing, laughing over that. Oh, guys. Like, you guys have the free pass to say cry some more, whine some more, because that's exactly what's going on in here. Literally, you get a gag order that you're arguing for, and then when the judge says it's for both parties, you're like, but wait, the DA responding to things. Where are we? We'll go back. We're like 45. Me breaking YouTube streams. Go back a little bit here.
3 days ago. I don't believe it. That was done in January 2020.
I already made findings.
I understand.
In my view, nothing nefarious. I don't want to, regarding what Sergeant Zizzo testified, so you can call it a gag order.
We will advise, obviously, courts where we've said nothing. We will advise the DA as well. To be clear, the DA responded to Mr. Tacopina's public.
This is him whining that it shouldn't go both ways. It should only be a gag order on the defense. I can't believe
Let
this.
everybody know in your office who may say something, tell them not to say anything to the media or the press.
Will do, Your Honor. We had two last issues which are brief. The first issue is we're going to request, and made this request before. Counsel and I've tried many cases in front of the court. If there's anything even close, I forward to the defense. If there's any evidentiary issue, which is even a close call, in terms of the defense interviews and bringing up ask the question, we want to make sure that they ask an approach and then forward to it. You don't want to be in a position to have to unring the bell.
That goes for both sides.
Finally, Your Honor, the court is aware. On Friday, it doesn't really matter what circumstances were. Mr. Tacopina literally started screaming at me in the. So, Your Honor, I'm not interrupting.
Screaming.
I see Mr. Tacopina makes noises. Again, if there's got to be a certain decorum, we're following it. But you can't bring a knife to a gunfight. So we would appreciate, as the court is respectfully instructed, there was one lawyer talking. The other lawyer not interrupted. Mr. Tacopina, as court's aware, started literally screaming at me in the courtroom. He basically appeared to challenge me to a fight. And again, I've been doing this longer than he has. I've not had that experience occur before. I am not going to be treated that way by anybody. I'm certainly not going to be treated that way in a court where I practiced for more than 30 years and in front of a judge I deeply respect. He doesn't have to like me, he doesn't have to get along with me, but he cannot be screaming at me, whether on or off the record. The court was here. The court, I mean, everyone.
Do we need a screaming counter? He said screaming 3 times since we finished rewinding and started playing forward. He's not saying screaming again because I did the rewind. He said screaming 3 different times for emphasis. Like, bro, why does it do this to me?
Everyone heard and saw it.
There we go.
Now, right. So I'm just asking that the court, again, Mr. Tacopina is an emotional guy, that the court advises him.
And you are, both of you are zealous attorneys, aggressive attorneys, both of you.
We are due to zealous aggressiveness. The court has not heard me yell or scream at anybody. And again, and it's not a request. I'm not going to take that.
All right, why do we do this? I did not hear you yell. I did not hear it. If it did happen, it wasn't in my presence. Because you two have this relationship, why don't you not talk to each other unless it's on the record?
Oh, that's,
And then I am involved.
that train is silly. Yes, absolutely, I agree with that. But I want to respond now, because, I can't have it always one way he makes a record disparaging remarks, and then I sit here. So, no one screamed, you were right there, Your Honor. What's happened, and Mr. C was with me, is Mr. Lewin comes up with his little scolding, sort of bullying attitude, telling me you don't know the rules here, and we're not doing this right, and he didn't like the opening statement, and so on and so forth. So I responded. I don't need a lecture from him, okay? I'm not going to go into the amount of phone calls I got regarding him and his reputation before this trial started, from lawyers I don't even know, including lawyers inside the district attorney's office, currently, okay? I'm not going to go into it, Your Honor, 'cause I'm not petty.
Wait.
No, now you're interrupting him. Just that you were complaining about him interrupting you, you're interrupting him. Don't.
I'm not going into it, Your Honor. I just don't want to do that, but please.
Is this
There's
Alex?
one
Is that his
thing
name?
There's an argument between both sides, both of us. I
In the
agree.
back.
That's not going to happen because I'm not going to speak to him off the record. So you're right about that. That's number one. Number two, I have to also raise an issue, and I'm not past that. I don't want to even talk about that. Your Honor was here. That's the end of that. Mr. Lewin did something last week that was inappropriate. The reason I'm raising it is because I don't want it to happen again. This week, Mr. Mayor's significant other may appear here. Last week, Mr. Lewin, as is his playbook apparently, with other lawyers, went up to my client's family and told my client's family that's not personal, but they should really, hopefully he's really thought about taking a plea because he's facing a lot of jail time, and saying things that played on the emotion of the family. He should have no communication with the defendant's family. I've heard he's done that in every case. That's what I hear. Well, I don't want him, and I want the court to instruct him not to communicate with anyone on this side of the fence. Not the client's family, not the client's relative, not the client's friends, because it's inappropriate.
So, Your Honor, so what happened was, I walked up very kindly to the defendant's mother and sister, and I said the following: listen, I'm very sorry that you're having to go through this. I have kids myself, I have siblings myself, I know it's not difficult, it's not personal, and I'm truly sorry for what you are having to endure.
All right.
And then I said as follows: I hope that your brother and your son, I hope that he's really evaluated what he's risking here, because he is a lot.
All right, there's nothing that prohibits,
At the time.
I've heard enough, There's nothing that prohibits what Mr. Lewin did. You've heard now that the defense does not want you to approach anyone from that side, so don't approach anyone from that side. It's as simple as that. All right,
Your Honor, again, this is one evidentiary issue we need to deal with.
Another one?
Yeah, unfortunately,
What is
and
it?
Mr. Lewin brings up
What is
four or two every moment. I just want the record clear on this. But the defense doesn't need to preview our impeachment material on an eliminate motion. Mr. Lewin keeps saying we need to bring it to the court's attention or his attention when we plan on introducing or using evidence so that he can have a 402 hearing. The law is crystal clear. If I don't need to go further, I won't, because we're on the same page. But the law is crystal clear that there's no rule of law that would require the defense to disclose evidence gathered by an investigator who may tentatively be called by the defense for impeachment purposes at Hubbard versus Superior Court. I'll continue. People versus Hunter. Section 105.4.3, subdivision A1, provides that, quote, defendant and his or her attorney shall disclose to the prosecuting attorney his or her intended witnesses together with any relevant written or recorded statements of those persons or reports and statements of those persons which we complied with. But the court goes on, but that does not include impeachment statements.
All right, go ahead.
But that does not include impeachment statements a defendant obtains from prosecution witnesses. The prosecutor is not entitled to statements impeaching prosecution witnesses, like People versus Hunter, People versus Sloan. Here, the defense, the court noted, could use the messages on the tape to impeach a witness without disclosing the tape to the prosecution. The prosecutor was wrong that using the tape for impeachment was the same as introducing it into evidence. A few more cases. People versus Ledesma. The court noted, to the extent the evidence at issue was submitted to impeach, counsel may have been unwilling to give the prosecution the benefit of a preview of the defense case in order to obtain such rulings, which is what apparently Mr. Lewin is seeking to do now. But the court noted that the defense was appropriate in the way it proceeded. Two more. Zaga versus Superior Court.
This is Zaga, yes.
Right. The defense is not required to disclose any statements it obtains from prosecution witnesses they may use to refute the prosecution's case during cross-examination.
And you're going to mention Phillips.
I'm going to mention Morrison, in which the court noted, nor did the discovery statutes obligate counsel to disclose she would impeach a witness with evidence of prior misconduct, particularly in that case, gun possession. Now, I understand, Your Honor, that the prosecution here wants us to do their homework for them, but the law doesn't require us to. For that matter, all of the impeachment material that we have arises from their own discovery.
All right, let me tell you my view on impeachment. I'm aware of this is Zaga, but that's a California Supreme Court case. There's another California Supreme Court case that's called People versus Tillis. Both of them say the same thing. Impeachment evidence does not have to be disclosed. Impeachment witnesses, once the decision has been made to call them, does have to be disclosed. But the evidence does not. All right, we are at 5 minutes to go. I don't want the jury to wait. So let's give Kathy a break, and if anybody wants to use the facilities, they can. I want to get started right at 10:30.
Don't need the full witness, just logistics. And
What's logistics?
Not controversial. The police evidence we put in on the defense.
Wow, they took a long break here. So they took like a 35-minute break here. So, there's supposed to be an hour put aside for motions arguments, and it looks like, if they got started about 3 minutes ago, they went 45 minutes over their allotted time for when they wanted the jury to come in. So, think, right? Stream math is difficult. On stream, my brain will be like, whoop. So, let's get caught up here. Jury, yeah. So much for not making the jury wait, guys. So much for that.
We had a little chat in front of the jury.
Also, I want to give a big shout out here. FFS is also out here sniping. So let's show FFS some love. A huge supporter of so many channels here. And we love having FFS in the chat. FFS, you held it down this morning as well. Like getting this stream kicked off, especially since we did an impromptu live stream. It was so great to have you here, like setting the stage. So big appreciation in the chat for FFS here. Thank you so much for gifting 4 memberships. Ruth Slappy is like, look, these gifted subs are not hitting me. I've just got to become green myself. So thanks so much for becoming a member and supporting the channel. Make sure you're using those custom channel emojis. We'll have to get some new ones because we've got a new trial going. I don't know, do you guys want like a taco or something? We need some new emoji ideas, you guys. Shamina's back for another trial watch. So exciting. And this caught me off guard. I didn't expect this to be so crazy, but here we are. And I'm going to go with Honeypot in the chat, who's like, guys, LA courts, LA prosecution, this is how they are all the time. So if there's cameras on the proceedings here, maybe they never expected this to see the light of day. They thought Rocky would plea out. I don't know. But it's on camera now, and there's thousands of people watching it. So that sucks for you, LA County. Chloe Albert Chervin says, so what is this court's policy on song lyrics? Because I think Rocky said something about standing under Riri's umbrella one time, and that was sus. And you know what? Were the lyrics like inscribed on the shell casings? Are we going to get social media posts? I hope we don't go there. I hope we don't go there. So far, I'm not really seeing that inclination, but I really think the prosecutor, it pained him to say that ASAP stands for always strive and prosper. I really think he didn't want to say that to the jury because it sounds positive, right? This is not a bang bang type of acronym. This is always strive and prosper. And the prosecutor paused a little bit before he said it. So, sorry. Thank you so much, Chloe. The Honorable, yeah, that with like this more than ever with the squabbling. Like they are inches from each other. At least the one prosecutor separated. The one that's doing the most arguing is separated by the other prosecutor, the one that delivered opening statements, and then Tacopina sitting here. But they're like squabbling verbally, and they're like so close to each other. So Honorable, yeah, that good to see you, says the court setup is weird. Why is the state and defense so close? Tiny courtroom. And they've got witnesses coming in the room. Who knows? But it is very good to see you. And Chloe says, Tacopina sounds like Andrew Cuomo. I think this is just a New York thing, you guys. Sounds like Cuomo when he gets excited. Mr. Whiny Pants better watch it, or he'll fatten his lip and then pet his wife. Yeah, there is a lot of touching. You know, ASAP put his hand on Tacopina's back after he did the live action emote cry. But really, like, the one prosecutor, he, like, grabbed the other prosecutor's hook. He, like, went to his neck and was like, and yoked him up over here. It's a little much. And maybe that's me. I get startled, so I wouldn't really like someone doing that to me, especially if I jumped and shouted in reaction. I'm in a courtroom where I'm supposed to be quiet. You're putting me in an awkward position by setting me up to jump, but maybe those two prosecutors have that type of comfortability. So yeah, so we're going to get into it. Susan just joined us. Great to see you, Susan. Missed all morning. Honestly, very entertaining, but the short of it, they had some discovery issues. Judge has said, guys, neither side, this is a short trial. Just don't talk to the press about this case now that the jury's been sat. Evidence as far as Relly's past, bad character evidence, can't come in unless it's included, maybe these conversations that he's had with ASAP Rocky or somebody else about ASAP Rocky within the last designated look-back period. So the judge is allowing a 1-year look-back for conversations Relly may have had with other persons, 2-year look-back for any communications that he had with Rocky that might be relevant. And what else did we have? It seems like we can only call the the witness Relly or Terrell Efron, like his actual names and his ASAP AKA. But we can't call him a criminal, a liar, an extortionist, which I think hurts the defense. We didn't really have an explicit ruling on calling him a victim, so I don't think that that's excluded, but maybe it is. So other than that, it was a lot of attorney squabbling, and in my opinion, the prosecution being extremely hypocritical. We don't want the defense to talk to the press, but hey, you're going to gag both of us? We don't like that. We want to have some freedom to say things to the press. You can't have it both ways. Take the win. To stop trying to split the baby, especially with this judge. And also, we're so upset because the defense didn't disclose to us every detail, every word that they had with an August 2024 witness, 2 different witnesses. They didn't disclose every single last detail of their interview content to us. Well, there's no burden. The defense doesn't need to do that. They got an intro on the time, date, sum, and substance turned over. And then what else do we hear? We hear like 20 minutes after that argument, the state, who actually does have the burden to disclose, didn't disclose key things to the defense. So all these arguments from the prosecution, they're double standards, they're hypocritical. Maybe there's a lack of self-awareness, but I feel like they're aware that they don't do these things and they're just choosing to whine to see if the judge will cave in. And sorry, you look stupid. And sometimes we tamper down on the chat, no insults, but if you guys want to call him a whiny